Listen-only mode.
Good afternoon. My name's Amy O'Hara. Thank you for joining us today. I know there's still some people getting on, but I don't want to delay too much because I have a lot of information to go through. Usually I only have about an hour today, and I have about an hour and a half worth of information. In terms of a couple housekeeping items, you'll see Mama put in a note that if you have any questions, just type them in the chat box. The audience won't be able to necessarily see, only Can, like the organizer and the panelist. And I will answer the questions at the end because I'm not going to be looking at that chat box while I'm speaking. So I'll look at it at the towards the end, and hopefully we'll have enough time to be able to answer questions. Also, if you have an interest in any future webinars on topics, just jot them down also, because we'd be interested to know, if we have many people joining us today, what you may be hearing, interested in hearing from Littman Krooks in the future. And they would be limited to special needs planning, special education, elder law, traditional trusts and estates, and special needs planning, guardianship, benefits advocacy, OPWDD. So that whole encompassing all of that. So I'm gonna get started, and I think we have. So I will be moving through these. Okay, I will be moving through my slides fairly quickly. I know that my office will be putting them up, I believe, probably on our website and or YouTube following. So if I go through things relatively quickly, you will be able to have access to them later. So overall, in terms of discussing about special needs planning, we need to be mindful of different types of government benefits that your loved one, and I'll typically refer to as your child, even though I know we have many callers on here who it may be a relative, a sibling, a friend, it could be a professional relationship, but I mostly will referring to the person with a disability as a child. They could be an adult or a minor, just in terms of terminology. So government benefits, I like to break them down into two types of categories, which are means tested and non-means tested. Means tested means that there's an asset and income test to be determined eligibility for these programs. For supplemental security income, this is through the Social Security Administration, and an individual needs to have less than $2,000 in assets in order to be eligible for SSI. The individual needs to have a disability and have limited or no income at all. In terms of Medicaid, Medicaid is a federal, joint, and state program, and each state promulgates their own rules subject to federal law. So Medicaid coverage in New York may work differently than if you're in Connecticut or New Jersey. For purposes of, if an individual receives SSI in New York, they receive automatic Medicaid coverage here in New York. If somebody is not eligible for SSI in New York, they may still be eligible for Medicaid. There's different types of Medicaid, which I'm not going to get into today, but there is an asset and income test with a Medicaid program. Sometimes there's spend down associated with that, and you have to put the spend down because the individual has too much income, but they still need Medicaid, and we could protect the income in certain types of trusts. Also, some means tested benefits are Section 8 housing and SNAP, which is a Supplemental Nutritional Assistance Program, which we know as food stamps. Non-means tested benefits, Social Security disability, which is again administered through the Social Security Administration. An individual can receive SSDI based upon their own work history or their parents' work history. If it's their parents' work history, the onset of the disability must have occurred before the age of 22, and be disabled within the meaning of the Social Security rules, and they have some strict rules on that. And also really have no work history themselves, that they're not really able to, the individual's not able to work, and then their parent has to either be collecting Social Security benefits themselves in the form of their parent, mom and dad, are retired, disabled themselves, or deceased. And though that is the trigger for the child or the adult child to be able to receive Social Security disability benefits, again, as long as the disability occurred before the age of 22, they don't have to start collecting before age 22, but the disability must have occurred before age 22, and they're unable to work themselves and have no work history. 2 years, or give or take, because now sometimes there is a 2-year or a 24-month rule that when somebody becomes eligible for Social Security disability, they will receive Medicare benefits, which is the same Medicare that all individuals are entitled to in the U.S. at age 65. It is common for individuals, or not uncommon, for people to have SSI, SSDI, Medicaid and Medicare, or some combination of those benefits. In New York, it's where the Medicaid can be very valuable is for applying for OPWDD benefits. That's New York State's Office of People with Developmental Disabilities, and there's different programs and services that an individual with disabilities who has a developmental disability can receive, and it's funded through Medicaid dollars. So when school-age children, when they age out of school at age 18 or 21, oftentimes if they're not able to work or go to college, they may fall into some program through OPWDD. If it's a mental health related disability, it would be through New York State Office of Mental Health. And there's different applications online for those programs. So special needs trusts, I'm going to go through, there's 3 main types of special needs trusts, and I'm going to break them down today. Not going to spend as much time on pool trusts, but there's a third-party special needs trust, which we refer to oftentimes as a supplemental needs trust. In New York, those words, supplemental or special, can be used interchangeably. First-party special needs trust and pool trusts. All of these type of trusts are created for the benefit of individuals with disabilities. And what is a trust? A trust is it's an agreement and an entity really in and of itself of assets that are held by one person or an individual or entity, which is referred to as a trustee, at the request of another person, which is the settlor, or you may hear grantor, for the benefit of another person, which is referred to as a beneficiary. Third-party special needs trusts. They're funded with assets that never belong to the beneficiary himself. So often a common example of a third-party supplemental needs trust is mom and dad taking care of their estate planning and creating their wills, and creating a trust, so whatever assets they want to leave to their child who is not able to have their own assets in their own name would go into a third-party supplemental needs trust. And the purpose of this trust is to provide supplemental source of funds without jeopardizing any eligibility for government benefits, the means-tested benefits that I mentioned before, including Medicaid and SSI. The beneficiary doesn't have to meet the strict definition of Social Security definition of disability. Sometimes in individuals who are higher functioning that have autism, they may not qualify for certain services under OPWDD or SSI because they may be pretty high functioning, but they still can't manage an asset or an inheritance. And so we would still want to protect that in some type of trust. There are no age restrictions with creating this trust. So you will see when I talk about a first-party special needs trust, the trust must be created and funded prior to an individual turning age 65. Well, with the third-party special needs trust, we don't have that requirement. There's also no payback requirement, which means that if you're creating this trust for purposes of your estate planning, and the assets are in trust for your child's lifetime, upon his or her death, if there's money remaining in the trust, you get to control who inherits that money. It could be the child's children themselves, your grandchildren. It could be their siblings. It could be charities. It could be other loved ones. The trust can also have more than one beneficiary. So I recently did a trust for a couple of twins who both had disabilities, and they were young, and mom and dad didn't know who would have greater needs at this point, and they really didn't want to do a 50-50 split. They weren't sure if it should be a 60-40 split in terms of their estate. And so at this point, because the children are young, their long-term, lifelong needs are not known, they decided to do one trust for both of their children. And the trustee will have discretion in terms of how to allocate funds for the benefit of each child. The trust is also completely discretionary, meaning the trustee has the ability to pay out trust assets for the benefit of the child, for whatever the child needs. So the one rule is that they could never give cash to and this is with all special needs trusts, so whether I'm talking about with third-party trusts, first-party trusts, pool trusts, the trustee will never be able to give cash to the beneficiary. And there's ways around that I talk about with families, such as if the beneficiary themselves are capable of having a credit card, the beneficiary could buy items on the credit card and give the invoice to the trustee as well as the receipts, and assuming that they're appropriate expenditures, the trustee can pay off the credit card. And there's other creative ways that we get around this no cash rule. The other way is, if they receive some type of benefit through SSI or Social Security disability, that's cash coming into the beneficiary's hands each month, and they could use that in terms of the cash needs, and the trust will pay for other items. Items include certain therapies, and I'm going to talk about housing and food in a minute, but a car, the beneficiary's cell phone, any medical needs that the beneficiary may have over and above what Medicaid, Medicare, or traditional health insurance may cover. The trustee can, and this is a common misconception, that a special needs trust cannot pay for food and shelter expenses. And shelter expenses including housing, rent, certain expenditures that go within the housing expense, but really, to pay for housing for the child. It can, and a well-drafted special needs trust give the trustee the authority to pay for housing, food, and shelter expenses. Just understand that if and that's directly to not giving the money to the beneficiary to pay for the housing and food expenditures, but paying them directly to the third party. If the beneficiary receives supplemental security income, SSI, and the trustee pays for food and shelter expenses, it's referred to as in-kind support and maintenance, and there will be a 1/3 reduction in the SSI payment. So that's common, especially living in the metropolitan New York area, where housing expenses are astronomical. It's very common for a trust to pay for housing expenses with the understanding that the beneficiary is going to lose 1/3 of their SSI benefit. If the beneficiary receives Social Security disability, SSD or SSDI, there is no reduction in that benefit. It's only related to SSI where there is that reduction. And this what I'm talking about now applies to third-party special needs trusts, first-party special needs trusts, pool trusts, and even parents who, let's say the child turns 18 and still lives at home with the parents, And you, the parent, but there is no trust in place. There's nothing paying, no trustee paying for food and shelter for the beneficiary, but you as the parent are providing food and shelter for your child. There is also that 1/3 reduction in the SSI benefit. So with third-party special needs trusts, as I mentioned before, these are typically done when we're handling estate planning for families. And the supplemental needs trust can take different forms. It can be drafted different ways, and it depends on the needs of the family and the goals and what the purpose is. A common way is a testamentary special needs trust, which is created under your will. And that type of trust actually does not get, it's created under your will, but it actually doesn't get funded or get a tax, get a social security number, what we refer to as a tax ID number. You can't open up a bank account. Other family members can't contribute to it until your will, until you're deceased and your will is probated. At that point, the trust can be funded. And this type of trust is commonly done for families when we handle their estate planning, and there's really no need. There's limited funds. There's not going to be large contributions during the child's lifetime, and if that ever changes, then we could go to what's called an inter vivos trust. That's a trust that's created for your child during your lifetime. It's a trust where we could create now and fund now, and other family members can contribute to it. And that's important to coordinate that you don't want grandma, grandpa, or an aunt to just leave assets outright to your child if they're expected, one, if they can't manage the assets, and two, if they're expected to receive government assistance through means-tested benefits. It's important that it take the form of a special needs trust, a third-party special needs trust, or the ABLE account, which I'll talk about in a little bit. Funding of the trust is done through a will. It's done through life insurance. It's sometimes retirement plans. It's really important to coordinate all of your assets with your attorney to make sure that everything is coordinated and funds the trust properly, that the beneficiary designations on your life insurance and in retirement accounts be done properly so that the trust is funded. And how much is enough? And there is no crystal ball to tell us how much is enough. And so there's no easy answer there. When we're dealing with families with young children, it's not uncommon to leave assets equally to all the children because it's not known what the lifelong needs of all the children will be. If the children are adults, and and depending on the size of your estate, if you have a small estate, you don't have that much in terms of assets, it's not uncommon to leave more assets to the child with a disability and less to a child who is capable and will be earning and have an income and be able to create their own wealth. If you are have some wealth in terms of assets, you could sometimes the adult child who has a disability may not need as much in terms of lifelong needs that maybe they're being provided for it already from the government in terms of housing and programs. And so it's special needs planning always evolves. I continuously meet with families when they have young children and then through transition into early adulthood and then later in adulthood, and needs change. So just keep that in mind that yes, it is good to have all of your estate planning done, but don't forget to revisit it every so often, at minimum every 5 years. Choosing a trustee is critical. It's very important. You don't want to just designate anybody. The perfect trustee will be knowledgeable in all of these areas I have listed on my slides: trust law, investments, public benefits, knowing about Medicaid, as SSI, knowing about education and medical issues. Well, it's always difficult to find the perfect trustee. And so we go with what we have the closest, and it's about putting a team in place of like I serve as counsel to various trustees and help them and give them, and sometimes they consult with me once a year. Sometimes they need more hand-holding, some don't, in terms of making sure that they're doing the right thing, and putting them in touch with a financial advisor and an accountant to make sure that everything is being taken care of properly. Sometimes we hire an advocate for the child to make sure that the child's day-to-day needs are being met. If it's not a family member that is active or a friend that's active in the child's life, or we're dealing with what's called a corporate trustee, which is a bank, a financial institution. You have control in choosing the trustee, and careful thought needs to happen. Sometimes families decide that they want to have both a corporate trustee and a family member to serve, because the family member will know the medical issues and the education issues and know how to advocate for the beneficiary, whereas the corporate trustee can make sure the investments are done properly, that the taxes and the trust law are all being followed at a fiduciary manner. So again, it's counseling and carefully thinking about who you want to select in managing this trust. And not only thinking about one trustee is hard enough for families, but if you designate an individual, you really want to think about a successor trustee, that if something happens to the primary trustee that you selected, who will be the backup? So, think about that. Also, compensation to trustee and caregivers. New York state law provides for compensation to trustees in the form of commissions. It does not provide automatically for compensation to guardians. So some families say, you know what, I have a different trustee than I do a guardian, and so I want to make sure that my guardian is compensated. So we will we'll build in compensation for the guardian in the trust agreement. We want the trust to be able to hire professionals, and sometimes put together an advisory committee. As I mentioned before, sometimes we have somebody who's very good in the trust law, and an accountant and a financial planner and an education advocate, and a family member, whereas an advisory committee could be or a trust protector. Let's say that we're dealing with a first-party special needs trust, which I haven't talked about yet, but there's a corporate trustee serving there as the trustee. Oftentimes we'll name a parent or other family member as a trust protector to give them the ability to fire the corporate trustee and replace them with another corporate trustee if for some reason the relationship's not working. Letter of intent. So I'm going to talk about that a few slides down. So a first-party special needs trust is funded with the beneficiary's own assets. This type of trust is not used for estate planning purposes. Okay, so it's not for part of your will. This is where the beneficiary, the child himself or herself, has their own assets. And the most common example of assets is through like a personal injury award, or a birth injury, or a malpractice where there was a medical malpractice and the child received a large settlement, and but still needs to be dependent on government benefits. We will put these assets in the settlement money into a first-party special needs trust, and the assets in the trust are exempt, and the beneficiary will still be able to have eligibility for Medicaid and SSI. Inheritance. So inheritance, oh, sorry, I moved the slide. If somebody didn't do their estate planning properly, or grandma leaves a bequest to their, thinking very well intentioned, let me leave my grandson who has Down syndrome, let me leave him $100,000 so that I know that he has money to protect him during his lifetime. Well, That doesn't help us if the child needs government benefits, or if he doesn't even have the capacity to be able to manage that $100,000. And we need to oftentimes put this money into a first-party special needs trust. Child support is another example, because that's an asset that belongs to the beneficiary, not the parent. With first-party special needs trusts, you can only have one beneficiary per trust. So you can't have multiple children be beneficiaries of a special needs trust. It has to be for the sole benefit of each child or each beneficiary. Again, distributions are discretionary by the trustee. The same rules that I discussed before in terms of the food and shelter and the reduction of SSI benefits apply here. The trustee can really pay for anything that the beneficiary needs directly to the third party, no cash or distributions directly to the beneficiary. The trust, it's required, there's a limited pool of individuals who could be the settlor or the creator of the trust. And that's the individual, which is that's a new law as of, it's not even a year old yet, that an individual can actually create their own first-party special needs trust. Somebody who has capacity, okay, they have to have capacity. A parent, a grandparent, a legal guardian, or the court. So it's a limited class of people who could establish this trust for the benefit of the beneficiary. And the Special Needs Trust Fairness Act is what I just mentioned, that it's not even a year old, that the individual himself can actually create a trust on his own where he's the beneficiary. Okay, there's a strict definition of disability, which the beneficiary must be disabled as defined by the Social Security Administration. It can't be limited on a medical diagnosis or a personal opinion. The beneficiary must be under the age of 65 when the trust is created. And when you fund the trust, and when a trust is funded with the beneficiary's assets, if they're receiving SSI or Medicaid, there is no penalty period. There's no, whereas if there was a gift made for SSI purposes, if a child gave away his money instead of putting it into a first-party special needs trust and gave it to his parents, there could be up to a 36-month penalty and no eligibility for SSI during that 36 month. What's very important with the first-party special needs trust is that when the beneficiary dies and there's funds remaining in the trust, to the extent that the beneficiary used Medicaid during her lifetime, Medicaid gets paid back from the funds in the trust. And that's any Medicaid paid during the entire life of the beneficiary, not just when the trust was funded, not only if the beneficiary is over age 55, or I'm just thinking of some certain federal rules, that not if, over only the last 10 years. It's from inception. So if the beneficiary started using Medicaid when she was 6 months old, and then she's 65 or 70 when she dies, it goes back to 6 months old, and the funds are used to pay back Medicaid. If Medicaid was received in multiple states, each state receives a pro rata distribution of the trust remainder. If there happens to be, because oftentimes the Medicaid lien on the trust is quite substantial, that I like to say that this is a use it or lose it trust, that you want to, ideally you want to spend the last dollar on the beneficiary on the day that the beneficiary dies. Okay, because it's a use it or lose it. If in the, because Medicaid liens are so substantial that, but in the chance that the Medicaid, there is still assets remaining in the trust after Medicaid is paid back, then any remainder in the trust is paid to the beneficiary's estate. Okay, and you'd have to go to court to have the funds go through. If the beneficiary was not capable of creating a last will and testament, then it passes pursuant to the laws of intestacy. If the beneficiary had a will and had the capacity to create a will, then the trust remainder would pass pursuant to how the will indicates. Pool trusts are a hybrid, they could be actually third-party special needs trusts or first-party special needs trusts. And what's different is that they're managed by a nonprofit organization. And the assets are pooled for investment and management purposes only, but each beneficiary has their own sub-account and their own money. Pool trusts are used commonly when there isn't family members or sufficient funds to have a corporate trustee. So there is no ideal trustee selection other than a pool trust. And there's some terrific pool trust companies out there that will that serve as trust, that handle these trust accounts. Pool trusts will also they're beneficial when there's extra income. In the beginning of when I started talking, I had mentioned that there's sometimes there's surplus income. Somebody has too much income, but they can still be eligible for Medicaid. Well, sometimes we put this extra income into a pool trust. And I'm going to move on now because I want to get through my ABLE slides. So good news, likely many people on the webinar today have heard about ABLE and the ABLE law. Well, finally, we have some good news for me to share with you that I haven't been able to with my last few seminars or webinars, that we could create them now in New York. We have the ability to create them now, and to join an ABLE account in New York. So that's something that's new. It's just over the last couple weeks. I have not had a client to be able to join one yet, so I can't tell you in terms of exact procedures. From what I could tell, it's similar to opening up a 529 account. It's managed by, you don't get to choose, that it's your local bank or anything like that. It's managed by one institution, similar to the way that Vanguard administers our 529 accounts here in New York. You are not limited to choosing a New York ABLE account. You could go to other states that have ABLE programs. So what is ABLE? ABLE is an Achieving a Better Life Experience Act. And an ABLE account is a tax-advantaged savings account that an eligible individual can use to save funds for qualified disability-related expenses of the account's designated beneficiary. Now, I'm going to break down what exactly this means. It allows for independence and control for capable individuals that may not have been able to have any assets because they need to have government benefits. Well, who qualifies as a designated beneficiary? So there are strict requirements into who can actually have an ABLE account. So an eligible individual is someone who is entitled to benefits on the basis of a disability or blindness under the Social Security rules, or can provide certification. So if the person, let's say, for example, doesn't receive SSI or SSDI at this point, but they could provide certification that they meet the criteria for a disability. And so you have to choose, meet either one of these first two prongs, and the disability or blindness must have occurred before the age of 26. So that's a key. So individuals, for example, who may have been diagnosed with mental illness at age 26 or later will not be able to open up an ABLE account. As I mentioned before, this ABLE account allows for independence and control, and allows individuals to retain control of assets in excess of $2,000. This $2,000 limit is what I had mentioned before in terms of the limit of assets for SSI purposes. The contributions in the account and the earnings in the account are not counted as income or assets. The account owner must be the designated beneficiary. So, but anybody can contribute to the ABLE account. If the designated beneficiary cannot create their own account, somebody who's their power of attorney or their guardian could create the account on their behalf. Only one ABLE account is going to be exempt. So if grandma opened up an ABLE account in Ohio and then and you opened up an ABLE account here in New York, it's the second one that was opened is not going to be exempt. So it's important to coordinate. Now, total contributions to an ABLE account cannot exceed the gift tax exclusion amount, and that's an IRS term. But what it means, you know, in lay terms, is that it's $14,000 right now. You cannot contribute more than $14,000 total in 2017. So if, let's say, your child has excess work earnings and cannot spend them, and puts them into, you know, but we're concerned about any too much assets in your child's names. So let's say they contribute $5,000 into an ABLE account. Well, but you want to make a contribution to the ABLE account. You cannot contribute more than $9,000 to that account. So the whole account cannot exceed $14,000. And the total contributions over time is limited to the state's 529 maximum. So except if the child or the individual receives SSI, if they receive supplemental security income, the account cannot go past $100,000. Now, New York State, and this is something that's unclear at the point, because right now our 529 maximum is $375,000. However, on the New York State Comptroller's website, it says that the maximum amount that can be in an ABLE account in New York is $100,000. I also called them, and they confirmed that that is correct. And I actually think that this is something that may be contested down the road, because I think it's contrary to federal law, that the account should be able to exceed $100,000 if the individual does not receive SSI. It's right now on nobody's mind, because it's impossible for an account to have more than $100,000 at this point, because we just opened them. So the most that any accounts in New York State could have right at the moment are $14,000 plus any earnings that may have been earned only in the last couple of weeks. So I imagine over the coming years this is something that's going to be addressed for these accounts to exceed $100,000 if the individual is not receiving SSI. The account grows federal income tax free, and it does qualify for an annual gift tax exclusion. So to the extent that somebody wants to give, $14,000 gift, which then it's not considered, it's exempt. There is no tax deduction though for contribution to the trust. So if a family member wants to make a contribution to the ABLE account, yes, it counts as an annual gift tax exclusion, but they don't take a tax deduction on it. If the withdrawal from the ABLE account is not for what is permissible, the earnings on the withdrawal will be subject to tax, as well as a 10% federal penalty, a surcharge. Now, so in the bottom point here on my previous slide, I said non-qualified withdrawals are subject to tax. Well, what are qualified withdrawals, and what can the ABLE account be used for? And this is right from our law and the Social Security rules, that qualified disability expenses include housing, education, transportation, employment training and support, assistive technology and related services, health, financial management, legal fees, expenses for ABLE account oversight and monitoring, funeral and burial, and basic living expenses. The Social Security, we don't have too many examples yet, but I will tell you that the ABLE account is pretty broad and what it could be used for, because qualified disability expenses for ABLE purposes has been defined pretty broadly. Basic living expenses, that is right in the Social Security rules, and that could be defined very broadly. In fact, in one of their examples, they use the payment of a cell phone, and buying a smartphone and the payment of a cell phone. So again, because the ABLE law is throughout the country is only a couple years old, and these accounts have really only been set up for maybe a little bit more than a year, and in New York State, only a few weeks. We haven't seen any really, that I'm aware of, any, you know, any decisions or information yet on narrowing these, you know, what the ABLE account can be used for. It is important to know that ABLE, if there's funds remaining in the account at the individual's death, it's similar to a first-party special needs trust in that Medicaid gets paid back. And that includes if family members contribute to the ABLE account, that they get paid, Medicaid gets paid back on those funds, on those contributions as well. Unlike a first-party trust, where Medicaid gets paid back for any Medicaid the beneficiary used during his or her lifetime, with ABLE accounts, it's only for Medicaid services, or what services Medicaid paid for since the ABLE account was established. Now, what are the pros and cons? You know, why, and I think that maybe a common theme of what I've been talking about here is that an ABLE account is not a substitute for a special needs trust. I think a special needs trust is very important for estate planning. And it's what's necessary, or some type of trust vehicle. Sometimes, you know, we don't need to be as strict with special needs trust, which isn't for purposes of today's discussion, but some trust vehicle is critical for your estate planning and leaving assets to your child. An ABLE account, I like to say, is another tool in the toolbox. It's, you know, because there are some limitations, you know, and that's what I'm going to go through now, is that, you know, with an ABLE account, we cannot contribute more than $14,000 a year into, and I want to clear, I don't know if I said that before, it's $14,000 per year. So if you make a $14,000 gift or contribution to the ABLE account December 2017, you could do it again in January 2018. It's on a calendar year basis. Whereas there are no contribution limits with special needs trust. Somebody could have multiple special needs trusts. Sometimes somebody may have a first-party special needs trust and a third-party special needs trust, or mom and dad are divorced and they want the special needs trust drafted differently with different trustees and different beneficiaries. So a child has two special needs trusts, whereas there could only be one ABLE account for that child. There is a Medicaid payback on ABLE, whereas, as I mentioned before, there's no Medicaid payback with third-party special needs trusts. We also have the age 26 limitation, that you cannot establish an ABLE account for individuals who became disabled after the age of 26. Not the case for special needs trusts. The ABLE account, you don't have investment discretion. You get to choose in certain generic ways to how to invest the assets, but unlike, you know, a special needs trust, where the trustee can really have full control over investments on the trust. We should consider ABLE to allow the beneficiary who's capable and give them some autonomy and control in their lives, because it could be access to funds greater than the SSI, and because the special needs trust cannot give cash to the beneficiary, this is another way, provided that the distributions are used to pay for qualified disability expenses. So here, just on this screen, and I have to move it along a little bit because as I mentioned before, I don't know when you joined me, but I have about an hour and a half worth of material that I'm trying to speak quickly and condense in an hour here. So you'll see here just some examples of how an ABLE account can be useful for your child. Letter of intent. This is really a non-legal document, but it's critical in providing information to future caregivers for your child. And it's a letter that you put together, and I've seen them several pages long, and it's something that you revisit and update. And it really provides a guideline for future caregivers. And it includes all family history, things that upset your child, ways to calm your child's daily schedule, your religious views, any type of funeral wishes, goals for your child, any doctors, or how often they see the doctor and what doctors they see. It's really everything about your child, from a day-to-day basis to everything that's happened in the past to what your future wishes are. Okay, the last, what I'm going to cover now is supported decision making. And there's been a movement over the last couple years in my experience in New York State with courts and the public and advocacy groups, and to really put in place the least restrictive alternative for individuals with disabilities as to what supported decision making is in place. And that really comes down to advanced directives and guardianship. Representative payee is solely for purposes of the Social Security Administration, and whether you become your child's agent under a power of attorney or their guardian through a court proceeding, you would still want to become a representative payee if your child's not capable of handling and speaking to the Social Security Administration on, on their own behalf. So that, just so you know, is something that you complete in with the Social Security Administration. So in terms of the advanced directives, the most common, and there's several out there, but I think the most critical for individuals, and this is also when your child turns 18. And I didn't start off with saying that when your child turns 18, they legally become emancipated from you, and you're no longer able to make medical decisions for them, or certain financial decisions. That in order for you to continue to do so, you have to have either advanced directives in place for your child or a guardianship proceeding. And what what I had mentioned before is that what's the least restrictive alternative for your child, and that's what the courts are heavily, more so than in the last, previously, but in the last couple of years, the courts are really focusing on this. That does the child fall on the level of needing a guardianship, but alternatively, can they sign a power of attorney and a healthcare proxy? A power of attorney is designating somebody who's an agent to be able to make all financial decisions on behalf of another person. So your child may designate you as the parent to be able to make make financial decisions. Healthcare proxy is everything medically related. So your child would designate the person who makes medical decisions in their life, on their behalf, as the healthcare agent or healthcare proxy. And the HIPAA release has to do with the healthcare proxy and the power of attorney having access to medical records, to the child's medical records, to be able to make informed decisions. Okay. If the child is not capable of really understanding what a power of attorney is and the healthcare proxy is, or there's some level of undue influence, that there could be a very strong concern of undue influence, that we want the protection of the court, then we would look to guardianship. And in New York, I think, today I'm really going to be focusing on 17A guardianship, which is our guardianship statute in New York for individuals with intellectual and developmental disabilities. And actually, that's my next slide. It's a plenary guardianship, meaning it's a full guardianship, and it cannot be tailored to the child's individual needs. It is done at our surrogates court here in New York. And this is, what I'm saying today is, it could be different 2-3 years from now and into the future, because there has been proposed legislation to really update this guardianship, that it's not a one-size-fits-all any longer, that we have individuals, that it's not a guardianship that provides for the least restrictive alternative, that maybe a child is not capable of signing a power of attorney and healthcare proxy, or there's some undue influence, and they need the guidance and structure of a court proceeding, but a full non-tailored guardianship is not the least restrictive alternative for that child. So as parents who may be on the call or advocates, you may have seen a lot of press or just different information going around on various listservs about this need to really reform our guardianship and bring it into the present and really tailor it to a child's unique needs and protect them for what they need, but allow them as much independence as possible. So that was just my little thing on that. And just to speak specifically about guardianship as it currently is in New York, it's designating, and typically, it's a parent or a loved one as a guardian for over property and healthcare. So personal is healthcare decision making, financial is property. It's in place. The guardianship is in place until it's revoked by a court. Whereas a power of attorney and healthcare proxy can be revoked, that if the child's unduly influenced, they could go to some place, or some friend brings them to some place, or, and has them revoke a power of attorney and healthcare proxy. So as a guardian for your child, you have the right to make medical decisions and legal decisions for your child. And this is, the proceedings, and I will say in most courts, I deal in about 7 different counties. So it is at the surrogate's court in the local county where you reside or where your child resides. Each county does it a little bit differently, or a lot differently than other counties, but I give yourself about a year from beginning to end for the whole process. Courts are backlogged. It takes a while to get the doctors to complete the requisite affirmations that need to be done, and the reports that they have to file with the court. There's a lot of follow-up there. So, give yourself, I always recommend that if you're going to be pursuing or thinking about pursuing guardianship for your child when they turn 18, start when they're 17 or right when their 17th birthday, start the process, because it takes a long time and it's frustrating. It's very frustrating for families. And I pretty much covered what the powers are. I'll leave it here for a minute, and then so you could read that slide, and then I'll open it up to questions. So Kian, if you have any questions for me, because I don't see any coming up on my screen here. And thank you everybody for joining today. I know I covered this very quickly. I believe that they will be made available on our website and YouTube. And if you have any, Kian, I'm sorry, excuse me one second. Just go back and maybe because they're typing something now, so because it's not coming up on my screen. Okay. And because I covered a lot today, that if you'd like to see some topics just broaden, where we focus 45 minutes on one particular topic, or other topics that I didn't cover today, let us know. We're interested, so that we, can provide the education to you. All right, and I'm just silent now to see if there's no questions. Okay, I'm going to sit on here for just a couple more minutes. So if you don't have any questions, you could hang up now. If you do have a question, you're still trying to type it into the box on the right-hand side, I'll give it a couple more minutes, and I'll be happy to answer them. Oh, one question came through. Nope. Okay. What? All right, no questions. So thank you very much for joining us today. We appreciate it. And how do I? Okay, thank you.